we are going to be calling the first case, which is three consolidated cases, 167-501 through 503. And that is the estate of Jennifer Fowler versus the estate of Helen Fowler. This is a mini oral argument on the application, so both sides will have 15 minutes for oral argument. There will be a 2-minute fire-free zone, which you're welcome to waive if you choose. And then for the appellant, you are entitled to reserve some time for rebuttal if you would like to. We just ask that you try and keep track of that. So, but you may begin when you're ready.
Thank you, Your Honor. May it please the court, David Highboy appearing on behalf of the estate of Jennifer Fowler and the Jennifer Fowler Trust. I will attempt to reserve 2 minutes. The factual issues in this case are not in dispute. The issues concerning the 401k plan or proceeds and the life insurance proceeds were never assets of the trust during Ms. Fowler's life. In fact, the 401k plan was a benefit of employment covered under ERISA, and it is agreed that during the probate court proceedings, since the plan had not been liquidated, Judge Tomlinson decided the case as if the plan had been liquidated, so we didn't have to come back and say, are we dealing with a plan where assets haven't been liquidated, or are we dealing with liquidated assets? And that is the basis of Judge Tomlinson's ruling in that regard. We also agree that the 401k not only was a benefit of employment, it obviously had never been liquidated by Ms. Fowler during her life, and as under ERISA, it was protected from any creditors from seizing those assets. Equally, the life insurance policy was a benefit of employment, had no cash value, and therefore during Ms. Fowler's life, there's no benefits to obtain whatsoever. Obviously, we have a situation while the basis of the claims against the estate, and they're probably 99.9% based upon the Helen Fowler estate. But the issue is whether the assets of the 401k, which is the 401k and or the life insurance, are subject to the claims of the Jennifer Fowler estate, which is undisputedly, it cannot satisfy its claims. And we submit that under 700.7506, that is the starting point. And clearly, any assets of the trust during the lifetime are available to the claims of the creditors, and here, those are separate matters. After the death of Ms. Fowler, and that's subject under NCL 700.7506 sub B, after her death, property of the trust that was, at the time of her death, revocable is subject to claims under 7605. Now, one of the issues that has been raised in this case is the nature of this trust. This was a revocable trust which became irrevocable upon her death. We're not contending that it's an irrevocable trust, it's a revocable trust. So then we look at 7605, and clearly our interpretation is that the property of the trust at the time of death is what is subject to the claims of creditors. And in this case, the 401k was not property of the trust at the time of Jennifer's death, nor was the insurance, the life insurance. Assuming this court disagrees with me and says, no, anything in the trust is subject to the claims of creditors. The Michigan legislature, when they adopted the Michigan Trust Code, and particularly 700.7605, included some exceptions, some exemptions. And that is why the Bollinger case out of Kansas, as cited by the Court of Appeals, has no application because it doesn't have any exceptions. If it's in the trust during life or after life, it's subject to the claims.
Counsel, so I tend to agree with you. I think the statutes, we do have these exceptions which are different than Kansas. But I'm wondering I'm assuming you agree with the probate section as to their view on the 401k proceeds and disagree on the life insurance proceeds. Correct. Can you help me understand, First of all, I think this case actually has pretty big ramifications.
I-
You would agree?
I
Yeah.
agree. Not even in creditors' rights, just estate planning.
Estate planning, agree. I think it's safe to say it's very common. Anybody who practices estate planning knows they advise their clients to name their trust as the beneficiary on all their documents. It's literally on the instructions by lawyers when you fund the trust. You have your revocable trust. Obviously, the whole point of estate planning is there might be tax issues. You might name beneficiaries where you can have, I don't know, you name your nieces and nephews and you want to help them pay for college or something, right? So you can like put stuff in a trust that you can't do directly. So, and of course, there's creditor protections usually, so unless there's exceptions. So here we are. My question is, how do you view the probate section's view on the life insurance analysis? They basically got there by saying, we have to look to the insurance code. We looked to 4, which says we can name someone directly. Yes, you can name a beneficiary directly. Of course you can on life insurance. In fact, it's what most people do. They don't name a trust. Okay, so you can name them directly. So then they say we have to look to the insurance code, though, to see if there's protections beyond that. The insurance code says if it's a spouse or kids, totally protected, creditors can't get you. If it's a named beneficiary, also can't get you, which makes sense because you could name them directly, except if it's an executor or administrator. And then they say, I think it sounds like, you know, the probate section seems okay with the idea that a trustee and administrator are the same thing, and that's really what this is here. Therefore, your client loses on that issue.
They're wrong.
Okay, tell me why they're wrong.
Okay, first of all, I'm happy we're not dealing with section 1, because I think somewhere they talk about the 8 or 9, whatever they are, paragraphs or semicolons or whatnot.
Yes, very antiquated notions in that paragraph, I might add, but yes.
I would agree that the legislature or the language is not up to date, so to speak, when it uses the word executor or administrators. However, when you look at the Michigan Trust Code and you see what a trustee is and what a trustee isn't, and what a personal representative is, and this is payable to, the issue is this would not be subject to the claims of creditors unless it's payable to the named insured, which it isn't, or, I'm not sure if it uses the word his or her, but I'll use the word his or her executor or administrators. And clearly, with all due respect, that is talking about the individual as an individual asset in a probate court, or a personal matter. And I think where the probate section missed it is they talk about, and the Court of Appeals use the same language, artificial entities. I think we have artificial entities everywhere. We have LLCs. In fact, I don't think anybody would ever use a partnership again when you have an LLC. You have corporations. You have trusts, and trusts, there are a variety of trusts. I think Chrysler or whoever they are today, you're making your payments to some type of a trust. And here we have the statute is clear that if the insurance, they don't want the insurance to be payable, even if it's payable to the named insured, they passed away, so it would go to their estate. And of course, their estate consists of the executor or administrator, whatever word is in vogue back when the statute was written. So from the 2207-2, this asset is exempt from the claims of creditors.
Yeah, go ahead.
Can I put a finer point on that? So I think there are 2 analytical leaps that the section makes, and I'm trying to understand which one, or maybe both, that you disagree with. So they look at the language executor or administrator and say that we can equate that to trustee, and then we can equate a trustee to the trust itself, the underlying entity. And so I think those are sort of 2 steps. Which step is wrong in your opinion, or where is that wrong?
Well, what they did was they bootstrapped the word administrate. No, they used the word that a trustee administers a trust, and therefore if a trustee administers a trust, they must be the administrator as set forth in 2207-2. And I'm not going to tell this court, I'm certainly not a wordsmith. I know Justice Bernstein is, but I am not a wordsmith on the word administer a trust versus what an administrator is. Because the Michigan Trust Code clearly defines what a trustee is. It clearly defines what a personal representative is, which includes an executor, includes an administrator, but it doesn't include a trustee. And so I think that even though the legislature didn't update the language, and I'm not suggesting that they're going to do that all the time, we can look at this and say this language is clearly looking at a situation where there is a life insurance policy on obviously the owner's life, that is either paid out to that individual, his estate, or his estate, and it applies whether it's an administrator, an executor, or the individual. Because I personally, I don't think there's any other way to read it. I know the probate court discussed a class of groups. The Court of Appeals simply said this is an artificial entity, and therefore they never even addressed further on that. In fact, and we rely on, there's not a great deal of case law out there, surprisingly.
And as a practical matter, would a personal representative have different access to that life insurance policy than a trustee, right? Because it seems like the statute is trying to, allow it for certain people and not allow it for others. Is there a functional difference in the work the access that a personal representative would have versus a trustee that makes that make sense?
I agree, and I think what the legislature is looking at is that if there's somebody out there, other than the individual himself or his personal estate, if that's who the recipient of the funds is going to be, it shouldn't go to them, because it's life insurance, there are creditors, and you shouldn't be able to circumvent your creditors by having your life insurance life insurance benefits be paid directly to you or to your estate. And so from that standpoint, that makes perfect sense. But when you have estate planning, and I'm not sure if this statute was enacted in 1956, but when you have estate planning, you're still looking at how do you fund things and who are you funding them for? Because even though Section 1 of 2207 talks about the beneficiary being a spouse or children or whatnot, there may be 50 reasons why you wouldn't want it going directly to your spouse or to your children, and you want it going into a trust so that somebody doesn't pull up on the second day after your death with the red Maserati, and you want to make sure that they go ahead, and whether it's an education or whether the money is paid out slowly. So this statute, 2207-2, is very consistent with the fact that it only applies to payments to the individual, his estate, or its administrators, and anyone else, as the statute says, the payments are free from creditors unless somewhere it was a fraud upon creditors. That would probably be some large payment was made, so it had a large cash value, and you tried to circumvent creditors, taking money out of your own account, putting it somewhere. We don't have that because we have an account that has no cash value.
So would you agree with me that it is pretty common to have a trustee also be a beneficiary? I mean,
Yes.
that happens all the time,
Yes.
doesn't it?
Yes.
You name your kids, and often maybe the lawyer in the family gets named as the trustee. So that's pretty common. So okay, what happens if one of the, sort of under the estate planning section or the probate section's interpretation, the trustee is an administrator, would it be just that person then who doesn't get the benefits? What about the other beneficiaries?
Well, no, the trustee, I hate to use the word, is the figurehead. That's the...
Right, because they're different. I understand, you're saying a trustee and an administrator.
Correct.
Maybe that's my question is reserved for brother counsel on that one, maybe.
Correct.
Yeah.
You would not be precluded as trustee because presumably the trust document, I would have to, would then set forth who these proceeds go to.
It's clear rules.
Correct. And even if it's the trustee, they would be receiving the funds as an individual versus as a trustee, because as a trustee, they have fiduciary obligations, and obviously if there are conflicts of interest or those types of things, those can be addressed in probate court.
So my final question, what do we do if someone is named as the executor and is also a trustee?
Well, in this case, they weren't. No,
I was trying to figure out how this statute,
I think they would
because I think
have,
that's probably common too.
I think they would have to probably give some type of designation. Well, I think they would have to give a designation of what hat they're wearing.
I see.
Because if it's simply Mary Doe, well, that's hers personally. If it's Mary Doe trustee, well, that goes to the trust. And if it's, I don't know that you would name Mary Doe PR, but if you did, that would go to the estate. And if for some reason there would be some kind of I don't want to say a lapse in beneficiary, I think that would go to the estate, the individual estate regardless.
So an executor sort of is like helping, I'm going to use the term administer, but, implement the estate planning. A trustee is over the trust. So it's not like an executor can be like, I'm just going to go write a check out of the trust.
No, correct. I
Right.
mean, obviously in today's day and age, we have our own words, but clearly a trustee is over a trust, whether it's a school trust or whatever it is, and the executor, PR, or whatever, that is the long-time nomenclature for a decedent estate.
All right, thank you.
Thank you. Your time has expired.
My time's up?
Sorry, we kept you up here, but
That's
very
all right.
helpful, thank you.
I'm sorry, thank you.
Thank you.
That's all 15 minutes too, isn't it?
Goes
It
fast.
goes really fast.
Thank you very much.
Madam Chief Justice and Associate Justices, if it please the court, I am John McNamee, and I represent the appellee, Julie Brooks, as personal representative of the estate of Helen Fowler. I'll try to address some of the issues that you raised here, and then I have a bit of what I would like to point out and highlight. First of all, Justice Welch, the dearth of cases involving this speaks to the fact that this is a very unique circumstance. In fact, when Brother Counsel filed his initial brief, he said it was unique. And the reason for that is, like under these circumstances, Jennifer Fowler had a son, and in 2015 he died. She did not have a spouse, and she had no other children or dependents. So at that time, she changed her estate planning. And instead of having her son as the beneficiary of the life insurance policy and of the 401k, she made her trust, her revocable trust, the recipient of those items. Now, counsel stated that the 401k and the life insurance policy at the time of her death was not property of hers. I mean, it wasn't property because it hadn't been paid out yet. And I have to say that I went to law school in the 70s, the 1970s, and I still remember Professor Downs stating to me and to the class that the differences between a revocable trust and an irrevocable trust, and the reasons why you would suggest a revocable trust and an irrevocable trust. And a highlight for the difference is that an irrevocable trust, you use it to try to shield tax consequences, such as when they change the amount of the marital deduction and that. You also use it if you think you're going to have a real problem with creditors, you've got financial issues, and you want to protect it, so you create an irrevocable trust where you are removed. You have to put it into a trust where you no longer have the say over that property. You give up your right to that in order to gain those protections. But if you have a revocable trust, everything you own or have an interest in is still within your control up until the time you die. Then, once you're dead, you can't make a decision after that point.
Well, right, at that point, it's irrevocable. We agree with that,
But when you
right?
say-
Once someone
but it doesn't
dies.
change it from being, it was a revocable trust at time of death. And if you look
But she
at,
couldn't take the money when she was alive and move it around. She could, it doesn't exist yet. She has to die first.
that's not necessarily true, because a 401k plan is not something that you don't have options on, whether if you want to withdraw or take it out earlier. You can. You can also designate who gets it. You can say, these people, my son is going to get this benefit. Or you can say the same thing with the life insurance. You have control. You own it. The interest in the Sparling versus Sparling case, which he says has no application, the Court of Appeals in that case said specifically that the use of the term at the time of death sets what is being considered. At the time of her death, she owned a 401k policy. In fact, counsel states that in his brief. He states, that although she owned the property, she hadn't received it. And think about it. Who else in this circumstance, up until the time she died, no one else had any interest or ability to change who got the money. No one had that power but her.
I have maybe what's an initial question. So this is an instance where the creditor is someone who's a creditor of her estate.
Yes.
But I assume that the more typical situation would be a creditor of the decedent or the settler in case of a trustee. Is your reading of 7605 that's irrelevant to our analysis of 7605, whether it's a creditor of the person who passed away or whether it's a creditor of the estate itself? I just want to, I know that's an initial sort of threshold question, but I
Well, it's my position that you don't even start at 7605. You start at MCLE 700.3805, priority of claim payments, insufficient assets. In this case, there was approximately $175,000 of estate assets, the sale of the mother's home, etc. The Sherry Spacel, who is both the administrator of the will, the executor, and also the trustee of the trust, revocable trust, they spent $175,000 in defending the wrongful death claim and appealing that, to which the Court of Appeals affirmed the jury's verdict. Now they are taking this to them was a deck action in the probate court to decide the remaining assets, the only ones that are left, are the life insurance proceeds, approximately $440,000, and the DTE 401k of about $1.1 million, so it's about $1.5 million. The verdict and the judgment and everything interest now is about $731,000. The only recovery that can be had, remember, Sherry Spacel is also this, what I'll call the balance remainder beneficiary of the trust.
Sorry, counsel, say we disagree with you that that's the starting point. If we disagree with that premise, can you then go back and answer Justice Thomas's question? Does it make a difference that this is a creditor of the estate as opposed to a creditor of the decedent?
Well, a creditor of the decedent, once you die, you only can make a claim against an estate.
Let me put it differently. Does it make
Let
me get the question out. Let me put it differently. Does it make a difference that it's a creditor that comes up in the context of a wrongful death suit, as opposed to, say, a car loan or something?
No, I don't think so. I don't think so. I think that you bring an action against an estate, and 700.3805 sets forth priority in an insolvent estate, which you go through. And then if there aren't assets there, then, and this is set up by the MTC and the EPIC, that says that now you go to a trust. And if it's a revocable trust, that's what you are entitled to. Not an irrevocable trust. You couldn't go after DTE 401k and say, hey, we want you to give us the money. You can't do that. Let me just point out, the Court of Appeals cut through all this shaft, in my opinion. There's a lot of legal gymnastics and attempt to seek loopholes to avoid having to pay a creditor out of a revocable trust. That's what this case is all about. It's unique circumstances. Probably won't see another one for 100 years. But it's a case in which the Court of Appeals said, they looked at the terms of the savings and stock plan and said specifically, they pointed out death of a beneficiary. If a beneficiary who is entitled to receive payments from the trust fund dies before receiving all benefits due, any remaining benefits shall be paid to the beneficiary's estate in a lump sum. And counsel keeps trying to suggest to you that since the 401k had not been paid out and the life insurance had not been paid out, it's not an asset of that trust at the time of her death.
So, Counselor, the probate section suggests that two things. One, under 7605, subsection 2, that the all payments from has meaning, and that meaning suggests that even once it's paid from the 401k, that it's of a piece of the kind of trust that would be in a 401K, and then under subsection 4, it would be exempt. So tell us where their analysis is wrong.
The analysis is wrong because it is not, that's referring to an irrevocable trust. If you're making a payment outside of, number one, you have to start with number one. Number one says revocable trusts those are available to creditors. You go through these different exceptions. 402 says that if she was still living and we were seeking to try to get at the 401K, subparagraph 2 says that's not available. That last paragraph deals with testamentary trusts, such as if you left in your will a trust to provide for your children, or up until the age of 21, common stuff. And it also applies to an irrevocable trust if it's paid outside. If it's paid outside of your estate, outside of your trust, that's an irrevocable trust. And the Court of Appeals said specifically in its decision, it says nothing in the language of 700.7605, this is at page 9, limits its scope to property that only becomes property before a settler's death. On the contrary, the statute applies to the property of the trust, which goes on to describe as referring to a trust that was revocable during the settler's lifetime. It is undisputed that Jennifer's trust was a type of revocable trust referred to in MCL 700.76051. Further, it is undisputed that Jennifer's life insurance policy named her trust as beneficiary. By virtue of that designation, the life insurance proceeds become property of a trust, bringing them within scope. And I'd also like to point out that the definition of an estate, okay, because when you start out with 3805 and then you go to the trust provisions, the definition of an estate, and this is MCLA 700.1104, subparagraph B. Estate, quote, includes the property of a decedent, trust, or other person whose affairs are subject to this act as the property is originally constituted and as it exists throughout administration. The state also has the rights described in sections 3805, 3922, and 7606 to collect from others amounts necessary to pay claims, allowances, and taxes.
Counsel, do you, so what do you think of the probate section's view on the life insurance proceeds? They obviously seem to agree with you ultimately on the result, but they seem to use a different analysis. What do you think of their analysis?
Well, I think, quite frankly, the analysis is pretty true in both, although the life insurance has specific statutory provisions that talk about you're exempted if it's a spouse or a dependent, which is not the case in this matter. And what essentially...
Right, but then there is a specific beneficiary. There were beneficiaries named in the trust.
Look, she could have done a lot of things, as was pointed out. She could have done a lot of things differently. She chose, her intent and her estate planning was to leave it to a revocable trust. These monies, her entitlement to the 401K.
She named her revocable trust, which had beneficiaries, and of course, then when she died, it becomes irrevocable, and now the trust. I understand your argument,
And
I understand.
beneficiaries are only entitled to receive what's left after you pay the administration expenses, after you pay the claims. There will be about $800,000 left for them.
Okay, so
If
my
you-
question is, the probate section does rely on, they obviously go into the insurance code to evaluate, whether there are spouse or dependents, and then also this other notion that if a specific beneficiary is named, that person can get the benefits unless they're an executor or administrator. Probate section basically says, trustee, administrator, same thing. Do you agree with that? As some,
Yeah,
like,
when you look at these statutes, they talk about, and as I just read that one, throughout the administration of the estate. The estate includes the trust. 3805 says, once an estate is insolvent, then you go to the trust. And that's part of the administration of the probate estate.
what
It's the
about
whole
this thing that we have a specific definition of what a trustee is in the state of Michigan? Do we just ignore that definition now and say it includes administrators?
Well, remember, the trustee's responsibility is once the personal representative requests the money to be transferred from the trust, it's the trustee's responsibility to transfer that amount, including trust, money from a trust, a revocable trust. She is the personal representative. She has an obligation to get that money and bring it into the estate so it can be paid out to a valid creditor. And my two clients are valid creditors. They've been through the ringer. They've gone through the wrongful death action. They've had it appealed. And now they're seeking to get compensation. And the people who are in control of the trust is the same person who's the personal representative, and they are recipients of the money in the trust which was left over after the probate is administered. They want to keep it all. My clients only want was to pay their valid claim. And the last thing I would say about the probate section, I'm not sure why they got involved in this matter.
I think we specifically asked for their view. I think our order may have asked them what their view was.
And I'll ask you this question. Do you have any questions for me regarding the last minute they come in with the revised judicature section about levy and sale if you're trying to execute on a judgment? And if you think that has any application whatsoever, please advise. Because that's the case in which somebody comes on my property, cuts down trees, I get a judgment against them. And that person doesn't want to pay my judgment. So then I use the judicature statute, the levy, and I execute on property. First I have to do personal property, I might have to do a creditor's exam, and then that doesn't solve it, then I can go after real property. It's a whole procedure. It has to do when your levy and sale, I can sell their property and get back part of my judgment. It has nothing to do with a complicated, not complicated, actually it's fairly simple, statutory construct of EPIC and MPC that says essentially, and by the way, all these cases, every one of them, and all the commentary always say, it has always been understood, black letter law, that a revocable trust is subject to the claims of creditors. And that's what we have here. We have a revocable trust that has $440,000 worth of life insurance paid into it, and will have another $1.1 million paid from a provision. And by the way, that's a contract provision. The Court of Appeals started out with that. That paragraph 5 says it's paid to the estate.
Thank you.
It's
Your
contractual.
time has expired. Thank you for your argument, and the case will be submitted. Thank you.
Thank you.